Hey, it's Matt. In this video, I'm going to talk about mistake number 8, and that is not understanding the basics of investor deal structures or how they may impact the company's sale outcome. Investor deal structures can have a huge impact on the financial outcome and control of the company, both from a strategic perspective as well as from an operational one. Over the years, I've seen a number of instances where it turns out that the founders perhaps did not fully understand the investor deal structure they negotiated in an earlier round. Here are some examples. 1, not understanding that a post-money valuation cap for a convertible debt round or a safe round is different than a pre-money valuation cap. 2, founders and early employees discovering that equity doesn't share dollar for dollar by share count with investors when you take into account liquidation preferences. 3, not understanding that the terms negotiated in an earlier round often have an impact on later rounds. In particular, they become the basis or the negotiating starting point for those later rounds. 4, unexpected dilution in a subsequent down round that not only causes dilution because of the down round, but as well as the adjustment that's caused on the shares issued in earlier rounds. And 5th, reduce control over the company or decisions that could be as basic as hiring and firing certain employees or setting and compensation of those employees. The best way to avoid this mistake is educating yourself. Learn the lingo, if you will. Liquidation preferences, participating preferred, anti-dilution provisions, pay to play, cumulative dividends, liquidation stacks, protected provisions. There's a whole vocabulary associated with early stage companies. And then once you understand the basics of that vocabulary, is know the differences between a priced preferred stock round and a convertible debt or safe round. In either case, what's often negotiated are financial terms and control terms. Financial terms could be company valuation, liquidation preferences, anti-dilution provisions, and control terms can be protected provisions, drag-along rights, board seats, and veto rights over various company decisions. After you've understood the basics on deal structures, then seek out additional assistance from experienced attorneys or entrepreneurs or mentors who have been through the process at least a few times. And then after you complete that process of getting the advice from others, then apply that advice by modeling. Take a look and model out the various variations of that next round of financing, then think through what that variation would mean for subsequent rounds of financing. Anyways, I hope that helps. Thanks for listening.